Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, listener learners, officials. I welcome all respected doctors and directors. I welcome all honorable ministers and managers. I welcome all honorable advocates, advertisers, administrative advisors. I welcome the most honorable President Pranab Modi ji. I welcome all those who are listening YouTube channel 3M Creator. Dr. Rakesh from USA, heartily cordially welcome. Let us go through today our holy Indian constitutional, cultural features, its identities in the form of unity and diversity. Right of passage over Indian territory case, Portugal versus India. In this case, the International Court of Justice pointed out that when in regard to any matter or practice, two states follow it repeatedly for a long time, it becomes a binding customary rule. The facts of this case are as follows. This case deals with the question relating to the right of Portugal to send its nationals and military to the Indian territory. Until 1954, Portugal possessed the right of passage to Indian territory, which was in between Dadra and Nagar Haveli and Daman. The right was, however, subject to control and regulation by India in between October 1953 and July 54. Certain incidents took place. The relation between India and Portugal worsened, and Portugal claimed that India was exercising excessive control. In July 1954, the people of Dadra, which was a Portuguese colony, revolted against the Portuguese government. It naturally had certain repercussions over the border areas of Indian territory. Consequently, the government of India suspended the right of passage of Portugal over this area. India contended that it had become necessary due to the special circumstances that had arisen Portugal took this matter to the International Court of Justice. The International Court of Justice had to decide whether India was entitled to exercise control over the way and whether Portugal could send its military or armed forces to the passes. The court had also to give its verdict on the point whether India acted contrary to its obligation. It may be noted that the claim of Portugal was based on the Treaty of 1779. The International Court of Justice decided that Portugal was not entitled to send its armed forces through the way which fell within the Indian territory. The court ruled that India did not act contrary to its obligations. The court, however, ruled that the Treaty of 1779 was a valid treaty and Portugal was entitled to get passage through Indian territory in consequence of the provisions of the said treaty. The decision is important insofar as that the International Court of Justice ruled that if under a treaty a state gets right of passage through the territory of another state and if it continues for a long time, then it gains the force of law and thereby imposes the obligation upon his state affected to continue to give right of such passage. It may be noted here that on 31st December 1974, a treaty was signed between India and Portugal wherein the latter recognized the full sovereignty of India over Goa, Daman and Diu, Dadra and Nagar Haveli. As pointed out by Brownlee, this case raised on issue of bilateral relations. The existence of a local custom in favor of Portugal in respect of territorial enclaves inland from the port of Daman. In this type of case, the general law is to be valid and the proponent of the special right has to give affirmative proof of a sense of obligation on the part of the territorial sovereign opinion. Juris is here not to be pursued on the basis of continuous practice and the notion of opinion. Juris merges into the principle of Agusenko. It may further be noted that in Ashlam case 1950 also the International Court of Justice held that where a local or regional custom is established in such a manner, it has become binding on the other party. Situation when some situation when same principle is found in customary law and is also codified in a treaty. This was one of the matters inter alia considered by the International Court of Justice in the military and paramilitary activities in and against Nicaragua. In this case, acceptance of court's jurisdiction effectively excluded disputes relating to certain multilateral treaties if claims were also based on rules of customary international law incorporated in those treaties. In the instant case, the court found that this identity of content in treaty law and in customary law did not exist in the case of rule invoked. While clarifying the position of law, the word court observed. Even if the customary norm and treaty norm were to have exactly the same content, this would not be a reason for he called to hold that the incorporation of the customary norm into treaty law must deprive the customary norm of its applicability as distinct from that of treaty norm. Further, more generally, there are no grounds for holding that when customary international law is comprised of rules identical to those of treaty law, the latter supervenes the former so that the customary international law has no further existence of its own. Importance of custom as a source of international law evaluation. There has been a marked decline in the importance of customs as a source of international law in modern times. This is mainly due to the fact that the process of the development of a new custom is very slow. However, in modern times also the development of new custom is possible and at times customs have developed with accelerated speed. Principles relating to sovereignty over air space and continental self are its glaring examples, but in view of the accelerated speed of the change in international community, custom has now become an adequate means for bringing about the changes and development of rapid changes can be effected through treaties and conventions so as to adopt international law in accordance with the changing times and circumstances. The four Geneva Conventions on the Law of the Sea 1958 and now the UN Convention on Law of the Sea 1982 to quote only a few examples bear testimony to this fact. The Soviet Union regards custom as an inadequate means for the development of international law. In one of his articles, Turkin has expressed the view that the development of custom also is based on the agreement between states. Consequently, customary rules are binding only on those states who have given their consent for them according to the Soviet view. Therefore, agreement between states is the only adequate means for the development of international law. In Southwest Africa case, Judge Tanaka observed briefly the method of generation of customary international law within the stage of transformation from being an individualistic process to bring a collectivist process. This phenomena can be said to the adoption of the traditional creative process of international law to the ability of the growth of the organized international community. It can be considered from the sociological viewpoint as a transition from a traditional custom making to international legislation by treaty. Thus, in the modern times, the importance of custom as a source of law has greatly reduced with the simultaneous rise in importance of treaties and conventions for the development of international law. But as pointed out by Edward Collins, international organizations also contribute to the development of customary international law by providing a clear, concentrated form for state practice, particularly in the General Assembly of the United Nations, where more than 106, now 185 member of states are represented. The statements and the votes of representatives on legal matters provide evidence of existing customary law as illustrated by the discussion on and the adoption of the resolution affirming the principles of the Nuremberg Charter and Judgment. Still, other resolutions amount to an interpretation of the rules and principles which the Charter already contains and which are in consequence binding upon member states authoritative by reason of the standing of the United Nations. General principles of law recognized by civilized states. Para 1 C of Article 38 of the Statute of International Court of Justice lists general principles of law, recognized by civilized states as the third source of international law. In the modern period, it has become an important source. It constitutes an important landmark in the history of international law in as much as the state parties to the statute did expressly recognize the existence of third source of international law independent of custom or treaty. This source helps international law to adapt itself in accordance with the changing times and circumstances. As pointed out by G. von Blaha, renowned author of international law, two views are prevalent about the phrase general principles of law recognized by civilized nation. According to one view, the phrase includes such general principle such as both sides of a dispute should be given a fair hearing and no one can sit in judgment in his own case, which are found in domestic jurisprudence and can be applied to international legal questions. The other view regards the phrase as linked to nature law as interpreted during recent centuries in the Western world. According to this view, general principle of law recognized by civilized notion have emerged as a result of transformation of broad universal principles of law applicable to all the mankind into specific rules of international. However, law of nature represents at best a vague and ill-defined source of international law. The former or the first view about the general principles of law is generally prevalent today. By general principles of law recognized by civilized states, we mean those general those principles which have been recognized by almost all the states. Owing to the gaps in the international law, it was felt that the competence of the court could not be confined to making judgments according to positive international law, like according to custom and conventions, but on the other hand, it was not designed to be free rein to the law-making activity of the court, and the court had to content itself with applying principles of law which could be established as common to the municipal law of all civilized nations and were therefore positive law. Though not positive international law, in the Lotus case, the Permanent Court of International Justice also observed the court considers that the words principles of international law as ordinarily used can only mean international law as it is applied between nations belonging to the community of states. It may be noted here that a principle of law which is recognized by domestic law of a large number of states does not automatically become a principle of international law. It becomes a principle of international law only when it is recognized as such by the word court. Judge Lutripach has therefore rightly remarked that the main function of the general principles of law has been that of a safety valve to be kept in reserve rather than a source of frequent application. The word court resorts to the application of this source only when in a case before it there is neither an international convention nor a custom in respect of the dispute resolved. Thus, Article 38, paragraph 1c of the Statute of the International Court of Justice places on record one of the main sources of the rules of public international law. Indeed, it describes the inexhaustible reservoir of legal principles from which the tribunals can enrich and develop public international law. By general principles of law, we mean those rules or standards which we find repeated in much the same time form in the developed systems of law, either because they have a common origin as in Roman law, or because they express a necessary response to certain basic needs of human association. Examples are the rule of pacta sunt servanda. Pacta sunt servanda, that contracts must be kept. The principle that reparation must be made for damage caused by fault. The right of self-defense for the individual against attack on his purpose or family and the community against clear and present danger. And the principle that no man may be a judge in his own cause, and that he who has to judge must hear both the sides. Further, we must emphasize that general principles of law and systems of Africa, religious law in India, and traditional laws in China and Japan. Thus, general principles of law recognized by civilized nations are indeed an symbol of those general principles which underlie, antedate, vary from and form the model of municipal rules of law, which are same in all jurisdictions and aim at justice in every case. In the view of Judge Chagall, principles of international law can be taken from the municipal law if they have received universal acceptance and are not inconsistent with any rule of international law. Res judicata, estoppel, etc. are examples of the general principles of law recognized by civilized states. These principles are such as have received recognition by almost all the states. They have therefore been included as the general principles of international law. General principles of law recognized by civilized states include procedural as well as substantive principles, provided that they have received general recognition of civilized states. The development of general principles of law recognized by civilized states as an important source of law has given a death nail to the positivism. Following are some of the important cases relating to the general principles of law recognized by civilized states. One is R.V. King. In this case, the court ruled that international law is based on justice, equality, and conscience, which has been accepted by long practice of states. United States versus Schooner. In this case, Justice Story of United States of America ruled that international law should be based on the general principle of law recognized by civilized states. He was giving decision relating to abolition of system of slavery. In the case of diversion of water from Bose, the Permanent Court of International Justice applied res judicata and estoppel. Corso Hatry indemnity case. In this case, the Permanent Court of International Justice applied the principle of res judicata and also held that one who violates a rule is liable to make reparation. Mavro Matish Palestine concession case. In this case, the court applied general principle of subrogation. Case concerning the temple of Prihivihir. In this case, the International Court of Justice recognized and applied the principle of estoppel. Barcelona traction case, preliminary obligation. In this case, International Court of Justice applied the principle of estoppel. Frontier dispute, Burkina Faso versus Mali. In 1983, Burkina Faso and Mali entered into an agreement to refer their frontier dispute to the International Court of Justice. During the agreements, Mali contended that form of equity or to be kept in justice. During the agreements, Mali contended that That form of equity ought to be kept in mind, which is an inseparable part of the interpretation of international law. Though Burkina Faso did not object to the said contention, it said that it was not clear as to what would be its practical objective in this case because in the delimitation of boundary there is no equivalence of equity principle. The Chamber of International Court of Justice held that it can take the help of that equity which both the parties have accepted or given consent to. The International Court have recognized as general principles. One is good faith, two is responsibility, three is prescription, four is in the absence of any express provision to the contrary, every court has right to determine the limits of its own jurisdiction. Five is a party to a dispute cannot himself be an arbitrator or judge. Six is res judicata, and seven is in any judicial proceeding the court shall give proper and equal opportunity of hearing to both parties. Since these principles have been recognized and applied by the court many a times, Beijing has, and rightly, to suggested that these and such other principles should be codified. In regard to the general principles recognized by civilized nation, the Soviet view is very narrow. According to the Casimir's, in a world consisting at this time of two opposed world systems, there are no such general principles except those established by international agreement as part of international law. This view does not seem to be correct because if this view is accepted, the International Court will have no right in respect of recognition of general principle with the breaking up of Soviet Union and end of communism in Russia. Cold War has ceased and hence this view has lost its importance. J.L. Bradley has rightly written that general principles of law is such a source which the courts have referred in past also and its inclusion in Article 38 1C of the Statute of International Court of Justice shows clearly that the positivist doctrine according to which international law is a body of rules on which the states have given consent has been rejected. From the theoretical standpoint, the provision for applying the general principles has been regarded as sounding the death knell of positivism in as much as it explicitly rejects the broad positivist view that customs and treaties are to be considered the exclusive sources of international law. Thus, by recognizing general principles of law recognized by civilized states, dynamism of international law, and the creative function of the international court have been ensured. Indeed, it enables rules of law to exist which can fill the gaps or weaknesses in the law which might otherwise be left by the operation of custom and treaty, and provides a background of legal principles in the light of which custom and treaties have to be applied, and as such it may operate to modify their application. Decisions of judicial or arbitral tribunals and jurisdict works international judicial decisions. In the modern period, International Court of Justice is the main international judicial tribunal It was established as a successor of the Permanent Court of International Justice. It may, however, be noted that the decision of International Court of Justice does not create a binding general rule of international law. Article 59 of the Statute of the International Court of Justice makes it clear that the decisions of the court will have no binding force except between the parties and in respect of that particular cases. Earlier decisions of the court are not binding on the court itself and the court is free to deviate from its earlier decisions. However, ordinarily, the court does not deviate from its earlier decisions and it changes its earlier decisions only in very special circumstances. Thus, while in principle it does not follow the doctrine of precedent in practice, it ordinarily follows it so far as the advisory opinion of the International Court of Justice is concerned. It is not binding at all, but it clarifies the rule of international law on particular point or matter. According to Article 38(1)(d), subject to subject to the provisions of Art 59, judicial decisions are subsidiary means for the determination of rules of law. Thus, judicial decisions, unlike customs entities, are not direct sources of law. They are subsidiary and indirect sources of international law. State judicial decisions may become rules of international law in the following two ways. One is state judicial decisions are treated as weighty precedents in the words of Chief Justice Marshall of the Supreme Court of America. The decisions of the court of every country show how the law of the nation in the given case is understood in that country will be considered in adopting the rule which is to prevail in that case. Decisions of the state courts may become the customary rule of international law in the same way as customs are developed. Decisions of international arbitral tribunals, in the view of some jurists, the decisions of international arbitral tribunals cannot be treated as source of international law. These jurists have rightly to pointed out that in most of the arbitral cases, arbitrators act like mediators and diplomats rather than as judges. The Kash Award 1968 bears testimony to this fact. Consistently, their decisions should be treated as source of international law. Generally, the said criticism is correct. It may, however, be noted that some of the decisions of the Permanent Court of Arbitration are treated as weighty precedent and can be regarded as source of international law. Letupach, Judge Letupach has aptly written one of the reasons usually given for it, that is Permanent Court of Arbitration in advocacy, was that the awards rendered by its tribunals were not legal in form and substance, that they tend to confuse law with a diplomatic solution aiming at pleasing both parties. It may be difficult to substantiate that charge. An analysis of the awards given by tribunals under the aegis of Permanent Court of Arbitration before and after the First World War must reveal that their decisions were legal awards in form and substance. Juristic was, although juristic was cannot be treated as an independent source of international law, yet the view of the jurist may help in the development of law. The view of the jurist are not direct sources of international law, but they sometimes become instrumental in the development of international custom. According to Article 38 of the International Court of Justice, the works of highly qualified jurists are subsidiary means for the determination of the rules of international law. The importance of the works of the jurist has been stressed by Justice Gray in Pekute Hasbena. Pekute Harana, in the words of Justice Gray, where there is no treaty and no controlling executive of legislative act or judicial decision, resort must be had to the customs and uses of civilized nation, and as evidence of these, to the works of jurists and commentators who, by years of labor, research, and experience, have made themselves peculiarly well acquainted with the subjects which they treat. Such works are resorted to by judicial tribunals not for the speculation of their authors concerning what the law ought to be but for trustworthy evidence of what the law really is. This case deals with seizure of fishing vessels, its cargoes, and capture of sailors during the state of blockade. The Paquet, Habana, and the Lola were two fishing vessels with Spanish flags on them in 1898 during the war between America and Spain. The warships of America blockaded the northern coast of Cuba, which was then a colony of Spain. The American warships seized these fishing vessels and, in order to punish them, started proceedings against them in the District Court of America. The District Court declared the fishing vessels and its cargoes as prize. The owners of the ship preferred an appeal in the Supreme Court of America against the said order. The Supreme Court of America reversed the decision of the lower court and ruled that the claimants be given the money derived from the sale of vessel cost of the case and compensation on the basis of the precedents and the established rules of international law. The court concluded that the fishing vessels and unarmed sailors who pursued their work honestly and peacefully could not be seized or apprehended during the state of blockade. International law example such fishing vessels and their sailors from seizure during the state of blockade. Decisions or determinations of the organs of international institution before the establishment of league and before the establishment of League of Nations. International customs and international conventions were recognized as the main source of international law. In addition to these main sources, juristic works and decisions of judicial and arbitral tribunals were regarded as subsidiary means for the determination of rules of law. The Statute of PCIJ under Art 38 incorporated these sources and also introduced one new source, namely General Principles of Law recognized by civilized nation. Article 38, however, did not at all mention decisions or determinations of organs of international institution as source of law. The reason for this was quite obvious that by this time international organizations had not assumed such an important role as they have done now. The evolution of international organization represents a significant stage in the history and development of international law. International organization, in its wider sense, is the process of organizing complexity of international relation. In a narrow sense, it is an international institution based on multilateral international agreement entered into by sovereign states. Its organs having autonomy of will, having permanent organs and having distinct entity or personality separate from its total of its membership. Even before the establishment of the League of Nations, some experiments were made for development of international organization. They can be classified into three stages: the Concert of Europe, the Loose Association of Great Powers of Europe, represents the first stage and may be said to contain seeds of present Security Council. The second stage is represented by two Hague conferences called Hague System. which contains the seats of present General Assembly of United Nations. Third stage is represented by the establishment of public international union such as Universal Postal Union and International Telegraph Union. Both of these are now specialized agencies of UN which contains the seats of present International Secretariat and specialized agencies. The League of Nations may be described as the first comprehensive experiment in the development of international organization which sought to combine all the above mentioned three different aspects of international organization. It has been rightly remarked that League of Nations pioneered all aspects of international organization. The UN had simply further developed, elaborated and perfected these systems. After the establishment of UN and of course the establishment of dozens of international intergovernmental organizations which were brought into relationship with the UN and called specialized agencies of UN. International organizations have become a part and parcel not only of international life but also of national life. Their impact is clearly evident on every aspect of our life. For example, if there is a scarcity of food grain, FAO comes to the rescue of nations and their people. If there is a health problem, for example, spread of disease, etc., WHO comes to our rescue in respect of problems of workers and labor. There is ILO, which has assumed such a significant role in this field that its conventions taken as a whole are called International Labour Code, which is said to be generally binding on all states. There is ICAO, which regulates relations of states in respect of international civil aviation, and the Council of ICAO is competent to decide any dispute relating to obstruction or to international civil aviation. CAO jurisdiction case India versus Pakistan 1972 is a glaring example of this. In fact, after the establishment of UN, most of the development of international law and its codification has taken place through the instrumentality of international organization. General Assembly, one of the principal organs of UN, has established International Law Commission, which not only surveys the whole field of international law but also prepares drafts and makes recommendations to these aspects to General Assembly. The General Assembly in its turn adopts its recommendations and recommends the holding of international conferences for adopting international conventions on different topics. A large number of international conventions have been adopted in this way during last 3 decades. The ICJ, which has rendered signal service for development of international law, is in fact a judicial organ of UN. Art 92 of Charter says the ICJ shall be the principal judicial organ of the UN. It shall function in accordance with the annexed statute, which is based upon the statute of PCIJ and forms an integral part of the present charter. In view of these strong reasons, the decisions and determination of organs are now recognized as an important source of international law, although they do not find mention in Art 38 of Statute of ICJ, but ICJ itself has recognized it in a number of cases. For example, in certain expenses of UN, the ICJ held that the expenses incurred by UN in Suez and Congo crisis could be apportioned among the member states of UN by General Assembly. It may be noted here that in both these crises, UN armed forces were sent under Uniting for Peace Resolution 1950. Thus, ICJ, though indirectly upheld the validity for Uniting for Peace Resolution, Similarly, in Southwest Africa cases 1966, Judge Jessup of ICJ remarked that numerous resolutions of General Assembly condemning apartheid was declared an international crime by International Convention on the Suppression and Punishment of Apartheid adopted in 1973, which came into force in 1976. The World Court had declared it as violative of international law, and obviously this decision was based on resolution of General Assembly as pointed out in the ninth edition of Copenhagen International Law. The fact that the International Court of Justice in its numerous judgments and opinions relating to international organizations has always been able, without remarking upon the incompetence of Article 38 to dispose of the questions arising for decision, is a strong argument for suggesting that their activities are for the movements at least still properly regarded as coming within the scope of traditional sources of international law, while at present this can be regarded as merely providing a different form for giving rise to rules which legal force derives from traditional sources of international law. There may come a time when the collective actions of the international community within the framework provided by international organizations will require the character of a separate source of law. In the view of Stark, organs of international institutions may lead to the development of international law in the following ways. One is गिरते बाजार व घबराए निवेशक, जगह जगह भीषण आग, पहाड़ों पर बर्फबारी, मैदानों पर ठंड भारी, बाजार में आए गिरावट तो नो प्रॉब्लम। दिल्ली, यूपी और बिहार प्रचंड ठंड, आईसीसी की दो टूक, भारत तो आना होगा। दिल्ली में बुलडोजर एक्शन, तनाव पथराव, दिल्ली में बुलडोजर एक्शन, तनाव पथराव, जगह जगह भीषण आग, जलकर खाक, पहाड़ों पर बर्फबारी, मैदानों पर ठंड भारी, दिल्ली बिहार प्रचंड ठंड, स्कूल बंद, आईसीसी की दो टूक, भारत तो आना होगा। दिल्ली में बुलडोजर एक्शन, तनाव पथराव, जगह जगह भीषण आग, जलकर खाक, पहाड़ों पर बर्फबारी, मैदानों पर ठंड भारी, गिरते बाजारों से न घबराएं निवेशक, ब्रेक बॉन्स, बाजार में आए गिरावट तो नो प्रॉब्लम। दिल्ली में बुलडोजर एक्शन, तनाव पथराव। In international matter, their decisions are the intermediate or final steps in the development of customary rules. For example, it was ruled by Security Council of the United Nations that if any member absent from the Security Council meeting, then it will not be deemed to be a veto. This decision has helped in the development of the international custom on this point. Similarly, the Security Council can decide whether matter is procedural or important. Such decisions may help in the development of an international custom on the point. Two is the resolution of the organs of international institutions may be binding on the members in regard to the internal matters of the institution. Three is organs of international institutions can decide the limits of their competence. Four is sometimes the organs of international institutions may make the interpretation of the different provisions of their constitutional instruments. This decision becomes a part of the law of international institution, which in its turn becomes a part of the international law. Some organs of international institutions are empowered to give quasi judicial decisions. European Economic Community deserves a special mention in this connection. Organs of international institutions submit some matters to the Committee of Jurists for their opinion. The opinion of the Committee of Jurists is of great significance and may help in the development of customary rule of international law. An organ of international institution may refer a matter to the International Committee of Jurists for its opinion or for investigation of a legal problem. The opinion of such committees bears some weight and authority. In case concerning military and paramilitary activities in and against Nicaragua, the International Court of Justice relied on resolutions passed by international organizations inter alia and cited them as evidence of the existence of customary rules. Thus, as evidence of customary rule prohibiting the use or threat of force in international relations, the court cited the Declaration on Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the UN as evidence of customary rule of non-intervention. The court cited the said Friendly Relations Declaration, the Declaration on the inadmissibility of intervention as evidence of a customary right of self-defense. The court cited the Friendly Relations Declaration and the General Assembly's definition of Agreement 1974. जेएनयू में नारेबाजी पर सियासत सुलगी, पहाड़ों पर बर्फबारी, मैदानों पर ठंड भारी। जेएनयू में फिर लगे नारे, बीजेपी ने जारी किया वीडियो। दिल्ली में बुलडोजर एक्शन, तनाव पथराव। Reference may also be made here to the decisions of the UN Administrative Tribunal in the case of effect of awards of compensation made by the United Nations Administrative Tribunal. The International Court of Justice held that the tribunal was independent and truly judicial body pronouncing final judgments without appeal within the limited field of its functions and not merely on advisory or subordinate organs. Its judgments were therefore binding on the UN organization and also upon the General Assembly. In other subsequent two cases, namely application for review of judgment number 158 of the United Nations Administrative Tribunal and application for review of judgment numbers 273 of the United Nations Administrative Tribunal, also the International Court of Justice upheld the decisions of the tribunal. Ex equo et bono, after enumerating the sources of international law, in Article 38.1, Article 38.2 of the World Statute qualifies Article 38.1 by providing this provision shall not prejudice the powers of the court to decide a case ex equo et bono if parties are agreed thereto. Thus, as pointed out by Manley Watson, in a case where the parties are agreed that it may decide ex equo et bono, the provision in the statute would seem to be enable the courts to go outside the realm of law for reaching its decision. It relieves the courts from the necessity of deciding according to law. It makes possible a decision based upon considerations of fair dealing and good faith, which may be independent or even contrary to the law. An international tribunal can decide a dispute ex equo et bono and go outside the realm of law only if such power has been conferred on it by mutual agreement between the parties. Some other sources of international law. Besides the above sources of international law, following are some of the other subsidiary sources of international law. One is international comity. The mutual relations of nations are based on the principle of comity. In other words, when a state behaves in a particular way with other states, the latter have also to behave in the same way. According to Professor Oppenheim, international comity has helped in the development of international law. To each state paper in the modern period, almost all the civilized states have diplomatic relations with each other. They send letters to each other for mutual interest. These letters are sometimes published. The study of these letters sometimes reveals that certain principles are repeatedly followed by states in their mutual intercourse. Sometimes these states' paper help in the solution of a conflict or controversy. In the famous case of the Caroline, 1841, the note of Mr. Webster, Secretary of State of the U.S. Reserve, is special mention here. In his note, Mr. Webster said that for intervention on the ground of self-defense, the necessity must be instant, overwhelming, leaving no choice of means and no moment for deliberation. Since then, it has been recognized as a rule of international law. Occasionally, an international controversy clears up a disputed legal point or advances the application of principles that have before received little more than an otious assent. 3. The state guidance for their officers. It is mostly seen that a number of matters of the governments of respective states are resolved on the advice of their legal advisors. These advices are also therefore sometimes treated as sources of international law. For its reason has occupied a special position in all the ages in modern period. Also, it occupies an important place. It has performed a special role in the development of international law. Whenever there is no rule of international law to guide the court, the matter is resolved on the basis of reason. By reason, we mean the judicial reason through which principles are discovered to face the new situation, which are considered valid by the jurist. When there is no treaty or particular rule of international law to resolve any question, the court applies judicial reason as pointed out by Pollock. The law of nation is founded on justice, equality, convenience, and the reason of the thing, and confirmed by long usage. The view of Pollock seemed to be correct in view of the conditions prevalent before the Second World War, because then most of the rules of international law were in the form of customs, and hence the court could take the help of justice, equity, convenience, and the reason of the thing to decide a dispute. The position had, however, changed after the Second World War when states entered into a large number of treaties to regulate their relations in different fields. When clear provisions of law are incorporated in treaties, the scope of applying the principles of equity, justice, convenience, and the reasons of the thing diminishes. The importance of these principles, however, does not completely end, because whenever the question of interpretation of any provision of a treaty arises, or where there is some ambiguity, the court interprets it on the basis of the principles of equity, justice, convenience, and the reason of the thing. The court gets an opportunity of applying these principles, particularly when there is some ambiguity about the meaning of any provision. Equity and justice. In the Barcelona traction case, Sir Gerald Fitzmaurice emphasized the need for a body of rules and principles of equality in the field of international law. Equality is used here in the sense of consideration of fairness, reasonableness, and policy, often necessary for the sensible application of the more settled rules of law. Strictly, it cannot be a source of law, and yet it may be an important factor in the process of decision. Equality may play a dramatic role in the supplementing the law or appear unobtrusively, unobtrusively as part of judicial reasoning. The principle of the exception, whereby existing rules are qualified to meet special cases in a form of equity, which takes on the form of judicial legislation. Further, equity in the present context is encompassed by Article 38(1)(c) of the statute and not by Article 38(2), which provides this provision shall not prejudice the power of the court to decide a case ex equue et bono if the parties agree thereto. This power of decision ex equue et bono involve compromise, conciliation, and legislation in a friendly settlement, whereas equity in English sense is applied as part of the normal judicial function. I thank all my brothers and sisters, ladies and gentlemen, students, scholars, teacher, trainer, professor, professional, officer, officials, those who are listening, watching, liking, subscribing, 3M creators. I thank all. Respected doctors and directors, honorable ministers and managers, honorable advocates, advertisers, administrative advisors, I thank the most honorable President Prince Modi ji. Thank you very much. Nice to see all of you. Have a nice day. Good morning to all of you. Thank you. Thank you very much.